Okay, it's Sunday morning and I'm making this video not having intended making it, but it's Sunday morning, I think it's the 26th of May, and you may have noticed recently some controversy leading up to the elections and even leaving aside the elections, European and local elections, about the Fine Gael TD who brought a personal injury action, brought a personal injury claim against a hotel in Dublin. The circumstances surrounding it were notable insofar as she fell off a swing in the hotel, apparently, and she brought a claim then in respect of her injuries. There was quite a bit of controversy about her, quite a bit of media comment, because the government of which she is a member, she's a Fine Gael TD, has an avowed intention of reducing personal injury claims and trying to help small business in getting down the cost of insurance premiums. And today then it was announced, I just read in the newspaper this morning, on the 26th of May in the Sun Independent, that she broke her silence about the case and she has confirmed that she's instructed her solicitor to withdraw the action. But there's a couple of things that are worth commenting upon and which you and I can take some lessons from, particularly if you're thinking of bringing a personal injury claim, or indeed if you are an employer or the owner of a premises or somebody who may be the target of a personal injury claim, or indeed a motorist. So that's a very, very broad sweep of people, obviously. So what I wanted to say was that Miss Bailey has withdrawn her claim, and she said that the fundamental point, or the basic point, was that she suffered an injury and had incurred expenses and costs arising from that injury. And that was her position. She said that was the bottom line, but in fact, and this is what I want to share with you, that's not the bottom line. That's only one factor in a personal injury claim. A personal injury claim at its essence is a negligence claim. It's founded on the civil tort of negligence. And in order to win a claim, a personal injury claim, you must prove negligence. You must prove that somebody was the culprit, was the cause of your injury. So in the ordinary course of events, in all of our lives on a day-to-day basis, we all suffer accidents from time to time, and we've injuries. But sometimes accidents just happen. And sometimes plaintiffs are sent packing from the courts with the tails between their legs because judges tell them that unfortunately accidents just happen. It's terrible what happened to you. I have sympathy for you, but nobody is to blame. And that's what happens from time to time. So that's a straightforward accident. Now Miss Bailey says that the bottom line is she had an accident, she was hurt, she had medical bills as a result of the accident. But she doesn't go a step further, the negligence piece. So essentially, to win a personal injury claim, which as I say is founded on negligence, 4 things at least must be present. 1, the person against whom you bring the claim, in this instance the hotel, must have a duty of care. That's actually not difficult to prove. If you go along to a hotel as a patron or as a customer or as a client or whatever, the hotel owes you a duty of care, and that's okay, that's easy to prove. The second thing is, you need to prove, if you're bringing the claim, Miss Bailey would have needed to prove that the hotel did not discharge its duty of care. That's the second part of a sort of a 4-part test. I'll come back to that. The third part is that she suffered an injury. It's easy to prove that. She may well have suffered an injury. She may well have had an unfortunate accident, and she may well have had the medical reports to support her contention that she suffered injuries. That's easy enough to prove. The final part, the 4th part, is that she has to prove that the injury that she suffered and the loss that flowed was as a result of as a consequence of the negligence of the hotel. So that's where we circle back to number 2. Number 2, she needs to prove negligence. And it was reported in the media that the basis of her claim and the particulars of negligence which she alleged against the hotel, I haven't seen the papers, but it's been reported in the media, The particulars of negligence were that the hotel should have had somebody supervising the swing. Now, to the ordinary man and woman, the idea that a hotel, or indeed anywhere else, a playground or a local county council, should have somebody supervising a swing is a proposition that's not going to find favour, I think, with the ordinary man and woman. And it's an appalling vista, in fact, in my view, that it would be held that the hotel would be obliged, that anybody operating a swing or a slide or a roundabout would be obliged to provide a supervisor to supervise the use of a swing. I have flashbacks to me as a little boy wearing short trousers, legging it across a field, legging it to a swing, and I wasn't hanging around when I got there figuring out who was the supervisor or where was the supervisor. I was happy enough to climb on board and swing away to my heart's content, and for most children it is fairly self-evident how you operate a swing and what can go wrong. But the bottom line is, from a personal injuries perspective, from a legal perspective, Miss Bailey says she has a legal entitlement, the same fundamental right as anybody else to bring a course of action, to bring a legal proceeding, to bring a claim in the courts. That's absolutely sure. But in order to win a personal injury claim, it's not enough that you've merely suffered an injury. You must prove that somebody else was the cause of your injury. You must prove causation. You must prove that somebody else was negligent, and that negligence ultimately caused your injury. And that would have been an interesting thing to see if the case had gone ahead in the court, either district court or circuit court or whatever court she was in, because I would have liked to have seen how her legal team were going to argue that the hotel was negligent in circumstances where it's alleged and reported in the media that she actually couldn't hold on to the swing because she was holding objects in each of her hands. There was also some drink taken. She's admitted there that she had a glass of wine. I'm not sure whether that's relevant or significant or not, but I suppose later on, if it ever came to that, there would be probably some contention about how much drink was consumed or that sort of thing. I'm not for a minute suggesting that too much drink was consumed or anything else, and I'm accepting completely Maria Bailey's assertions and statements in today's Sunday Independent that she suffered an injury, that she had one glass of wine, and so on and so forth. I'm merely making the point that if you're going to bring a personal injury claim, you need to prove negligence. And if you are defending a personal injury claim, you need to prove that you were not negligent. And there's four fundamentals, as I say, that I've mentioned in the video here so far about proving negligence. And her difficulty would not have been proving that she suffered an injury. Her difficulty would have been proving that the hotel was negligent. She's withdrawn that claim now anyway, but I hope there's a lesson there for all of us, and it's worth, I think, discussing and commenting upon and sharing. And if you want to read the blog post on my website, I'll put a link underneath this video. I deal with it. Well, look, I wrote the blog post this morning. It took an hour, and that's it. I published what I thought was fair comment on the situation, and I published what I thought was something that might be educational and might be helpful for anybody either thinking of bringing a personal injury claim or defending a personal injury claim. Hope you find this video useful. Give it a thumbs up down below if you do, and thanks for your comments and shares and likes and support generally on the YouTube channel. Thanks again.